How long is too long? The statute of limitations provides the answer to that question. The statute of limitations is the maximum time you have after an act before you can be time barred from bringing a lawsuit. Now, with most claims, it runs from the last date an event occurred. So, for instance, with a breach of contract claim, the last breach of contract starts the running of the statute of limitations for purposes of filing a lawsuit. But the rule is different for the right of publicity. There is the so-called single publication rule, where the time to file a lawsuit runs from the first general distribution to the public. Now, why is that different? Why a different rule? It is intended to prevent multiple claims. So, for instance, where there's been a publication in a newspaper to a mass audience, or a publication in a magazine to a wide audience, or book publication or radio ad or TV ad, there's distributed to a mass audience. So the time to sue starts to run from that distribution. Now, each subsequent broadcast or each edition starts the time to sue again. It's a single publication. Now, the rule is different for repeated publications to individual users. And there was a recent case where an authenticating company authenticated the signature of a celebrity to over 14,000 individual users, but it was done over time and on an individual basis. And there, the statute of limitations started to run upon each individual authentication. So, the lesson is, if you are concerned that your name, image, or likeness may be misappropriated, you should monitor it, because the time to sue runs very quickly. Set up a Google alert, or search for your name, search for your image, search for any likeness in all of the major search engines. It's the only way to really ensure that you'll know when there's been an unauthorized use. Next, we'll talk about the right of publicity and the First Amendment.